Let me give you guys a little bit of a teaser. Today is the due date, but it's due by the end of business day, and so I'll just give you the rundown. You may notice that the Supreme Court of the United States is in the letterhead. I am once again contacting the Supreme Court justice children to inform them of my various stances on things. Specifically, to give you a quick rundown, specifically in Greer's lawsuit, which began 5 long years ago, we won, and then the 10th Circuit Appellate Court made an absolutely preposterously terrible decision that completely muddied the waters in regards to what is fair use and what is knowing infringement and vicarious liability in copyright infringement. This decision was terrible, very bad, and we petitioned the Supreme Court to overturn this very terrible, bad decision. Less than a year later, this decision has appeared on both sides of a case called, I believe it's Sony v. Cox. And what the gist of this lawsuit is very dangerous and very important. In Sony v. Cox, Sony is alleging that Cox Communications, the internet service provider, is vicariously liable for all torrenting and piracy that occur on its entire network, which is millions and millions of consumer broadband connections and internet connected homes throughout the entire United States. So they're basically saying that Cox has a legal obligation to them to police the entire internet for any possible infringement that may be impacting negatively their intellectual property. This is preposterous. This is dangerous, and hopefully they are going to lose. But it has ended up all the way in the Supreme Court. And what's very funny about them being in the Supreme Court is that both of them have favorably referenced Greer v. Moon in their case, in their defense. So they both say that Greer v. Moon supports them because it is such a terrible decision that you can look at it any which way and come to any number of conclusions. So we are filing what's called an amicus brief. An amicus brief simply means a friend of the court filing, and we are asking for clarification on the very good, bad, no good 10th Appellate Court decision. In particular, if the Supreme Court rules on Greer v. Moon and says that actually it was a very terrible decision, I instantly win my case again. So for good this time, because it went up to the Supreme Court. So technically, Cox Communications here might not only win a huge victory for internet speech and expression and fair use, but may inadvertently cut the Gordian knot that I've been waiting to get cut for a very, very long time. It's true. It is my fault. It's my fault. I did this. So this is filed both on behalf of myself and also the United States Internet Preservation Society as an amici curiae or something. I don't know. I'm not a lawyer. I can't pronounce Latin. But we are in support of petitioners. So we are supporting both of the petitioners and seeking clarification. Now, Hardin has, with the assistance of Nathan Lindes, who he offloads the Supreme Court writings to for some work, has gone over, this is the table of contents, they're not done putting this together. It will be filed by the end of business today. Very cool document. They're very, very, very specific rules in regards to how you can file something with the Supreme Court. So there is a literal monopoly for printing documents to the Supreme Court, and it's very expensive. So if you would like to support my internet endeavors in this capacity, you can go to shop.usibs.org, and that money would go to the 501c4. Oh, I didn't even mention USIPS is now officially a 501c4 in the eyes of the IRS. We're no longer simply a South Dakota nonprofit. We are a federally recognized 501c4. So if you would like to become a member, it's $35 a year. You can go to shop.usibs.org and get a membership, and that will help offset the expense of filing this with the Supreme Court. The general request that Hardin has put forward is, most generously, he would like the Supreme Court to basically cull contributory copyright infringement as a concept. His core argument is that contributory copyright infringement does not come about as a result of any legislation. It was basically invented by the court system in 1905 or 1908. And since then, it's gone through many changes just as the result of the courts changing their mind about certain things, expanding certain things, restricting certain things, reversing earlier decisions. And this has been going on for over 120 years now. Meanwhile, there's no actual legislation which exists that creates the tort known as contributory copyright infringement, which now Sony is using to try and deputize internet service providers against their own customers. So his most broad strokes request of the court in this ruling is that we simply do away with the ideas of contributory copyright infringement until it becomes an actual law that is passed by the Congress. His narrowest request to the court is that the concept of actual knowledge and the terms of contributory copyright infringement are further clarified. So it's rather short for a court filing. It's 40 pages, but as you can see, a lot of this is tables. And then the pages themselves are quite short, with citations being half of each page. So it's very easily understood, well referenced, and respectfully submitted on behalf of Joshua Moon and the United States Internet Preservation Society. Oh, there it is, right down. Counsel for Amicus Curiae, Joshua Moon, and United States Internet Preservation Society. Isn't that nice? What a nice font, chat. How dignified, how special. So, that would be nice. That would be the funniest possible way, as I said before, to end the Greer suit, is if the Supreme Court of the United States says, yeah, that's all bullshit. That would be really awesome. That would make me feel very special. Okay. And making me feel special is the most important thing.